Welcome everyone. Thank you so much for joining us for this webinar on non-disclosure agreements in sexual harassment matters and discrimination matters. We're really keen to chat a bit more about the case for law reform in South Australia. My name's Maddie. I work at Working Women's Centre SA, and I've got Emma here with me, who's our advocacy officer. We're really excited to talk about this issue. It's a really important moment for law reform in this area because we've just seen, as of the 1st of July, new laws come into effect in Victoria restricting non-disclosure agreements, and these are the first laws of their kind in Australia. And we've also seen a commitment from the South Australian government to introduce legislation after consultation restricting NDAs. So there's some momentum building after many years of advocacy from unions, workers, and advocates on this issue. So that's really why we wanted to put on this webinar and why we wanted to do it now. And we're really grateful to you all for your interest and for joining. In particular, there will be an opportunity in the second half of this year likely to contribute to consultation on new legislation in South Australia, and so we really wanted to provide a bit of a briefing for everyone on the issue of NDAs so that you can contribute to that consultation. Before we get started, I would like to acknowledge the land that we're on. So here at Working Women's Centre SA, we're joining from Kaurna country and work on Kaurna country. I'd like to pay respects to Kaurna people, Kaurna elders, and acknowledge the long-standing and ongoing culture that First Nations people have here and all over the continent that precedes colonisation and Western legal systems that we're working in. Some people might be joining from other countries, so if you'd like to let us know in the chat where you're joining from, please do. And just acknowledging that it always was and always will be Aboriginal land. So I do just want to introduce ourselves for anyone who's new to the Working Women's Centre. We are a non-government organisation and community legal centre. We were really born out of feminist and worker movements. I've been around since 1979, and we provide legal advice, information, advocacy, workplace training and representation to workers. We have 3 different arms to our work. The first is legal service, so we're a community legal centre and provide support and advice around workplace issues to workers that don't have access to other support and advice. The types of issues that we really focus on are sexual harassment, discrimination. We also have an education program, so we run workplace training in all sorts of industries, which is all about prevention. And similarly, we do advocacy, which is very connected to this webinar today. We're really interested in how the same issues come through our legal centre again and again. We know they're systemic and looking at systemic solutions. So today we've got quite a lot to cover. So we want to provide a broad overview of workplace sexual harassment in Australia and talk about what are non-disclosure agreements. Really focus on the impacts of the misuse of non-disclosure agreements on people who've experienced harassment and how we've gotten here. Where has this momentum come from on a global and national level for this as an industrial rights issue over the last decade. We'd like to share some strong principles for law reform on NDAs in Australia and also run through some of the key features of the new laws in Victoria, which set a really helpful example for us. We'll share a bit about the case for law reform here and how people can get involved with the campaign as well. I do want to say up front that it probably will be quite an information-heavy webinar because there is just so much to share. So be prepared for that. We are hoping there might be a bit of time at the end for a Q&A, so feel free to put questions in the chat as we go. We probably won't get the chance to see them until the very end, and we might have to see how we go for time. So I'm now going to get straight into it and talk a little bit about sexual harassment in Australian workplaces. The reason I want to start with this is because while sexual harassment is very common, it's also a very hidden issue. And we can't really talk about NDAs without talking about workplace sexual harassment. So workplace sexual harassment is very prevalent in Australia. 41% of women and 26% of men have experienced it in the last 3 years. That came from the latest national survey done, which is a big national survey of workers. And really broadly, what that boils down to is 1 in 3 workers had experienced sexual harassment in the preceding 3 years. So it's very, very common, more so than most people realise. When you zoom out to a lifetime experience, 89% of women have experienced workplace sexual harassment in their lifetime. And when people are surprised at these statistics, perhaps one explanation for this is the use of NDAs and the fact that there's a silence around it. We also know that workplace sexual harassment is underreported. Most people don't report it if they're experiencing it. So it's about 18% of harassment is reported. And for some people, their experience of reporting harassment is actually more traumatic than the experience of harassment itself. It can be a really isolating experience, and there's many forms of silencing that people experience. So there's a number of barriers to reporting, and this is one of them. I also just want to highlight that sexual harassment happens to all workers in all industries, and can happen to people of all genders as well, not just women. So some broader context that's interesting is about occupational segregation. So Australia has one of the most gender segregated workforces compared to similar countries around the world. This basically means that we have a lot of industries that have a largely male workforce or a largely female workforce. The language here is a bit binary just because of the nature of how the data has been collected and the statistics that are available. And also just want to mention that while we have these highly male-dominated workforces in certain industries and highly feminized workforces, even in the industries where it's mostly women, often the leadership is still male-dominated. So we have some information about which industries have higher rates of workplace sexual harassment. Some of these are listed here. So we've got IT, arts and recreation, electricity, gas, water and waste, mining, retail, agriculture, forestry and fishing, accommodation and food services. This comes from that national survey that I mentioned earlier. And some of these industries here that have higher rates than the average are male-dominated. So this is a risk factor for sexual harassment, and that's because the majority of workplace sexual harassment is perpetrated by men. I do want to note that while some industries have higher rates of sexual harassment, it is common across all industries. So there's no industry that it doesn't have this issue, even though many people might think that. I'd also just like to note that the report that we've mentioned here, the Gender Economic Equality Study by Jobs and Skills Australia, is a really interesting way to find out more about that occupational segregation and how that influences this issue. The final thing I'd like to note about sexual harassment before we dive into the NDA issue is how it interacts with discrimination. So workplace sexual harassment often goes hand in hand with other forms of discrimination like ableism, homophobia and racism. This is the experience of many of the clients of the Working Women's Centre, where they might be experiencing harassment and also discrimination at the same time in the same workplace. Sometimes there's an element of discrimination to the sexual harassment itself. So For example, many workers who are LGBTIQA+ might face intrusive questions about their body or relationship or sex lives. So this can be seen as sexual harassment, unwelcome conduct of a sexual nature, but it also has that discrimination element in that it's about gender and sexuality as well. So that's just an example of how harassment can tie in with discrimination. There are so many other ways that it does, which we won't go into. You can see that reflected then in the statistics, where the rate of sexual harassment is higher for Aboriginal or Torres Strait Islander workers, disabled LGBTIQA+ workers, migrant or refugee workers, or young workers. So they've all got experiencing higher rates of sexual harassment compared to the general population of workers, which is 33%. So we just wanted to emphasize that as a key feature of sexual harassment, that can't quite isolate sexual harassment on its own from discrimination. And this is also an interesting statistic to contemplate. So people who hold strong sexist or other discriminatory attitudes are over 15 times more likely to engage in sexual harassment. So those attitudes are the strongest predictor of this misconduct. And that helps us see that sexual harassment is really tied in with broader systems of inequality, like gender inequality. Before we continue, I just want to note that it can be disheartening to hear about and read some of these statistics about sexual harassment, but everything that we know about these issues is that harassment is preventable, completely preventable, and actually the majority of people want to do the right thing and want to find solutions. One of the biggest things that's getting in the way of us doing that is silence and the fact that not everyone's able to talk about it. So I'd now just like to explain a bit about what is an NDA. I know we've got people here from legal sector, but not everyone might be in the sector, so just provide a bit of an overview. So traditionally, an NDA, the origins of NDAs was to protect commercial interests and trade secrets. So it's about keeping information secret. And it's now kind of evolved to be much broader, now used in many different contexts. So when someone experiences sexual harassment in the workplace, and if they do choose to make a report, they could either make a report or a complaint internally in their organisation, and they also have the option to make a legal complaint through various avenues. And if they make that legal complaint, one of the most common ways that that would be resolved, rather than going to trial, is for that to be settled. So that would involve a payment usually from the employer to the person who's experienced harassment as a way of resolving the issue and releasing the employer from liability, and not continuing with that claim. So that's where often these NDAs come into play. So if there is a settlement around a sexual harassment matter, often the agreement that's made would include a clause that has some element of confidentiality to it, so requiring either one or both parties to keep secret the issue. This includes both non-disparagement clauses and or confidentiality clauses. And like I mentioned, it could be included in a settlement or deed of release. They can also be included in employment contracts or other contracts. So the NDA is a clause usually within a broader agreement or contract. So more broadly, we could describe an NDA as a clause that prevents one or both of the parties from disclosing details about the sexual harassment complaint, investigation, or terms of settlement. And often these NDAs are really tightly limiting what someone can disclose about the matter. Many of them operate in an unlimited way, so they apply forever. And what we know is that these are used pretty commonly. So there was some research done, which we'll talk a bit more about later, about the use of NDAs. There is no database of NDAs, so we don't know the exact numbers of how often they're used, but what we do know is that 75% of legal professionals who work in this area have never reached a sexual harassment settlement without a strict NDA. So that shows that they are kind of being seen as and being used as the standard. However, we can kind of question whether they're really a standard term. There is no law, statute, or common law that dictates that NDAs are required. So that tells us that the use of NDAs is cultural in the sector. They're often included in an agreement just as a matter of practice, a standard practice. Having said that, there is no mandated standard for what that looks like or what the NDA actually says. So it's not necessarily consistent, but it is seen as standard. And that's what this research into the use of NDAs found, was that most commonly lawyers are advising clients, either applicants or respondents. So the applicant might be someone who's experienced harassment, the respondent might be the employer most commonly. And so they're not necessarily advising people that NDAs are standard, or they're advising them that they're standard, or not necessarily advising clients that they're optional and could be negotiated. What we would argue is that financial compensation around sexual harassment is to compensate for the harm that's happened and the loss, not to buy silence. And this expectation of buying silence, the more that we are talking about this and learning about it, is that it can be really harmful to victim survivors and to our broader efforts to try and prevent sexual harassment in the first place. I'd like to just share this quote from a worker, a lived experience advocate who experienced sexual harassment and then went on to sign an NDA as part of the settlement. She said, "I regret it immensely. I can't even tell my parents. I feel guilty every day that those people are out there and that there's no repercussions for them. There's absolutely no repercussions for what they did to me." And this really stuck with me when I first saw this, and it reflects the experiences that many workers do have, which is signing an NDA and then having some experiences of regret around it. So NDAs do typically prevent workers from speaking about their experience, which makes it difficult to get the right support. They likely will not be able to talk to mental health professionals or doctors, friends and family. So that can be really harmful in trying to heal from what's happened. And there's some research from the UK that shows that 95% of people who signed NDAs experience negative impacts on their mental health. There's this real silencing effect, and workers often feel like they have no choice but to sign an NDA if they want to resolve the issue. That comes back to that statistic again, that 75% of legal professionals have never, ever reached a settlement without one. And finally, we're concerned about how this really standard use of NDAs is hiding systemic problems in workplaces and discouraging action for change by protecting those responsible. A really troubling statistic is that 59% of people who have experienced sexual harassment in the workplace, they said that their harasser had also targeted others. So that shows that it's more common than not to have repeat perpetrators, which makes the use of NDAs problematic in trying to address the ongoing risks in the workplace. Often when people want to report harassment, they might cite their primary motivation as being to protect others. And we believe NDAs could be getting in the way of this. So I'm now going to share a short video which was created by the Working Women Centre Australia with the Lived Experience Network, which is a group of advocates who have experienced sexual harassment in the workplace and are speaking about this issue of NDAs. After the video, I'll hand over to Emma to talk a little bit more about the law reform and what's happened in Victoria.
I was sexually harassed. I felt unsafe. Nothing was done about it. I felt I wasn't supported. He shouldn't have touched me, and he crossed every boundary that I've ever set for myself.
It was very hard to do my job because there was sexual harassment and abuse happening. Being so passionate, so excited and so into it, but having to deal with being terrified at work was just unacceptable.
I was basically given the option to settle, and in doing so I was required to sign a non-disclosure agreement. I felt that it was presented as a non-negotiable in order to achieve the settlement.
I was a union delegate in my workplace. The perpetrator told me not to tell anybody. He was in a very senior position. I was not. They thought it would be in my interest to sign the NDA. I wouldn't have been able to talk to my husband. I wouldn't have been able to talk to my parents. I wouldn't have been able to talk to my children. I wouldn't have been able to talk to my best friends. You're not just silenced in terms of talking to the general public, you're silenced across your whole life.
The NDA protected him and not me. I was being silenced again, which is just re-traumatising for any woman going through this.
When we walk around as women who have been sexually assaulted in the workplace, victimised, bullied, discriminated against, we carry that invisible trauma with us every day. You can't see it.
It is incredibly difficult. I mean, at my lowest point, I have had some thoughts of suicide.
Some days, even just getting out of bed was a real struggle. I was really depressed, and my anxiety just went through the roof.
To get where I am today, it's been a long process, but I'm not going to give up on it.
I know what's happened to people around me and other women in the industry. It's happening right now.
I do know of other workers who've been pressured into signing NDAs. This can include for things like sexual assault or sexual harassment, but also bullying and discrimination. So it is quite broad.
Work's a huge part of our life, so we should always feel safe at work. We just have to do something about it. This can't continue. It's just dehumanising. It's
really important to be able to reclaim your voice, tell the story, the true story in your own words, and get some of your power back that way.
We need to come together and we need to stand up and fight for everything that we've worked for in the last 50 years.
Out of everything that has happened, this is my silver lining. This is giving me purpose.
I want to be heard, and I want my voice to be loud, and I want the other women to know that they're not alone and that something needs to be done.
Politicians need to decide whose side they're on. Do they want to be on the side of people who sexually assault people at work? Do they want to be on the side of people who sexually harass people at work? Or do they want to be on the side of victims who want to speak up and let people know what's really going on in their workplaces?
I'd love for this campaign to make women safer. I just really hope we can change the laws so that if they know if they stand up for themselves, they're going to be listened to, believed, rather than just being silenced and being told you're the problem again.
I'm speaking out today because no one else should ever have to experience what I went through in any workplace. These actions have real consequences on people's lives. People and employers in positions of power must be made accountable.
Join us to call on the Australian Government to introduce strong laws that will end the misuse of NDAs.
Our silence is not for sale.
Just give us a moment. There we go. Great. Hello. Thank you, everyone, for that. My name's Emma, and I'm the Advocacy Officer here at the Working Women's Centre, and so I'm now going to take you through the case for law reform and some of the kind of history of this campaign and the momentum towards regulating non-disclosure agreements in workplace sexual harassment and discrimination matters. So we know that, and NDAs, as everyone here knows, has become a very prominent issue around workplace rights. It came from the Me Too movement of starting sort of 2017, 2018, and particularly with even at that time, as people would remember, celebrity cases in the States where artists and actors had signed non-disclosure agreements, were breaking those non-disclosure agreements in order to be able to talk about this culture in that particular industry in the States. But that opened up a tsunami of Me Too stories, as people may remember at that time. And those stories included everyday workers, everyday women who were signing non-disclosure agreements all the time. For sexual harassment matters. And we know that there's been a really, one of the great things over the last decade has been a really big emphasis on listening to the stories and voices of victim survivors, as we just did now with that excellent film made by Working Women's Centre Australia and the Lived Experience Network. We've also known that there's been extensive media investigations into different types of employers and coverage of this issue, both in Australia and globally. And there's been a great deal of inquiries and reports and research that have all recommended that non-disclosure agreements need to be regulated and that they are harmful to victim survivors and harmful to changing the prevalence of sexual harassment in our workplaces. And then we've also seen fantastic legal sector and union advocacy around this issue, advocacy from victim survivors themselves, of course, and examples of law reform from around Australia, which kind of sets the bigger picture context of what we're talking about. So when we think about where does change occur around non-disclosure agreements in sexual harassment matters and sexual harassment in the workplace itself, we're talking about workers and victim survivors actually speaking up. And as I said before, a real emphasis now on listening to the experiences of victim survivors and their lived experience and what they recommend could have changed their situation at the time. We're talking about cultural change, which there has also been quite a lot of that in Australia and elsewhere, where there's been legal practice guidelines, voluntary legal practice guidelines, union-led change, and also voluntary employer change at times as well. And then, of course, we're talking about law reform. So that is legislation that changes how we think about non-disclosure agreements and how they are regulated in use for everyone. We need all of these things. We're not saying that law reform is the only thing that will change the way that non-disclosure agreements are used in sexual harassment matters or sexual harassment itself in workplaces. We actually need all of these things. But we do need law reform to ensure we're not simply relying on very courageous victim survivors like the women that you just heard from, or simply, good lawyers, good employers, etc. We want to have a regulated system for this use. So just to think about some of the reports in Australia that have impacted on the way that we've thought about non-disclosure agreements and what has been recommended. Of course, there was the national inquiry into sexual harassment in Australian workplaces that reported in 2020 by Kate Jenkins AO, who was the Sex Discrimination Commissioner at the time. On election in 2022, the Albanese government committed to implementing all 55 recommendations of the report, including those that required Commonwealth legislation. And we've seen two major federal acts that have actually made some changes to the way that workplace sexual harassment has been dealt with. And it really it's basically a shift from a kind of complaints-based model to a much more proactive preventative system, including the introduction of positive duty laws, which I'll speak about soon. We also saw that in the Respect at Work recommendations, in the report and the recommendations, it spoke a lot about the negative impacts of non-disclosure agreements and made a recommendation that there be issued guidelines for best practice of non-disclosure agreements, and that occurred in December 2022. In March 2024, this report was produced by the University of Sydney by Regina Featherstone and Shamila Bargan, and it looked at what was the use of non-disclosure agreements since the Respect at Work report. And that's where that 75% statistic that we've mentioned a couple of times now has come from, which really showed that NDAs were continuing to be used and misused, and that we needed a different approach which actually protected public interest, that stopped women from being unfairly silenced. Then last year, we had essentially what was this kind of second, or sort of a report that followed up the Respect at Work report by the Human Rights Commission, again now under Dr. Anna Cody. And this report, speaking from experience, it really it was a very extensive report that kind of spoke to over 300 victim survivors who talked about their experience of workplace sexual harassment, and it made a range of recommendations regarding what needs to change to deal with sexual harassment in Australian workplaces. And it really sharpened the recommendations that had come from the Respect at Work report. So it made a recommendation that there needed to be legislative reform to restrict the use of non-disclosure agreements and take proactive steps around prevention of discrimination and sexual harassment. One other report I just want to refer you to as well is the Community Legal Centres Australia. They did an action plan for the 48th Parliament of Australia, which they released in the lead up to the election, and they in September 25 last year, and they kind of really talked to, of course, we're now in the 48th Parliament of Australia, and they really talked to actions that prevent people from using from using violence to weaponise laws and government and legal systems to hide their harmful behaviour. And they also recommended restricting the use of confidentiality and non-disclosure agreements. They made a range of very interesting recommendations around defamation reform, which we don't have time and won't go into now, but are related and important. So if we look at employers' positive duty and what we call social licence, so positive duty requires employers to proactively ensure their workplaces are free from sexual harassment and discrimination and unlawful conduct. And we would put forward that, in fact, the use of non-disclosure agreements in many ways actually prevents employers from meeting these positive duty obligations under the Sex Discrimination Act, which came in December 2022. We think that what's really important is we know that employers, especially large corporations, some are now voluntarily making these changes for their own reputations because of campaigns and, pressure around that needing to deal with sexual harassment in the workplace and not silencing women and other victim survivors and silencing workers is actually part now of what we would call their social licence and is important to their reputations. I'll briefly go over this global effort to restrict non-disclosure agreements and some of the key pieces of legislation of different parliaments around the world. So in Ireland, we had this Maternity Protection, Employment Equality and Preservation of Records Acts, which actually has a very strong section in it around restricting non-disclosure agreements, and people who might be more familiar with the non-disclosure agreement campaign and issue will know that this is often referred to as the Irish model, and it was very much part of what informed Victoria's legislation process. In North America, there's been quite a range of federal and state law reforms, both in the States and also in Canada, and a lot of them have been around for several years, so 2022, around those times. And in the United Kingdom, did a very extensive overhaul, basically, of its industrial relations systems and act last year with the Employment Rights Act, which was a mammoth act, and that also restricted and regulated it's phrased as essentially banning non-disclosure agreements for workplace sexual harassment matters in the UK. And then, of course, now we have the Victorian legislation here in Australia, which that was passed in December last year and has just began its enactment from the 1st of July. And we certainly want to note how hard won this piece of legislation was, particularly by victim survivors, by unions in the Victoria Trades Hall leadership, and as well by community legal centres and community legal advocates in Victoria. And all of these legislations have made the use of non-disclosure agreements basically the exception rather than the rule, and that's like a key part of the principles of law reform. So, as I said, we have this Victorian legislation, and we're very, very pleased that the South Australian Government has committed to legislate to regulate non-disclosure agreements here in South Australia, taking into account the reforms that have happened in Victoria. So it's a key part of their industrial relations policy launch in the lead up to the election, and we're very pleased that the government have committed to this process, and we'll speak a little bit more about how you might be able to contribute to that towards the end of the presentation. So there are 6 principles of NDA law reform. I'm just going to have a little sip of water. So you'll see these across different types of legislation around the world, and certainly they're informing the Victorian legislation and what we would propose in South Australia. One is that any law reform actually needs to have a goal and be consistent with a goal of ending the causes of workplace sexual harassment and discrimination. So they need to be, any laws and NDAs themselves need to be consistent with other principles such as workplace health and safety, including psychosocial hazards. It needs to be, consistent with positive duty requirements of employers, and it needs to be also consistent with, the notion of the public interest as well. We want legislation that can be comprehensive and intersectional in its framework. We think that, that often will come from a single standalone piece of legislation, and that's what we've seen obviously in Victoria. But whatever the case is, legislation needs to apply to sexual harassment and discrimination, and we will speak a little bit further about that. But Maddie talked about the interactions between discrimination such as racism, homophobia, transphobia, and also definitely discrimination towards workers with disability as well is very much linked to sexual harassment experiences in the workplace. We want the laws to apply to all types of workplaces and workers, and for the law to basically have that presumption that non-disclosure agreements are not the rule, they're the exception. They're not a standard clause. Legislation needs to be trauma-informed. It needs to address these kind of power imbalances that workers and victim survivors experience. So that means that NDAs in all these law reforms can be only initiated by the victim survivor, by the complainant themselves. NDAs need to meet certain ethical preconditions in order to be lawful. So these are prescribed legislative preconditions that must apply to any circumstance in which someone has signed a non-disclosure agreement in a sexual harassment and discrimination matter at work. And they do need to provide some way for anyone who's signed a non-disclosure agreement, even when they sign an NDA, that there are what is called permitted disclosures, and that's a set of people and organisations that person is still able to speak to in order to gain support, even when they have signed a non-disclosure agreement. Clearly, there needs to be the right for information and independent advice, and for people to have enough time, to seek and reflect on and make informed decisions from that advice, as well as mandatory information statements that actually give people very, very clear information about what an NDA is, what the the kind of things they should be considering about whether they want to sign an NDA or not, and that this is also part of an act, part of the regulation of an act, that there's the same information going to everyone, and that the information and, of course, non-disclosure agreements themselves are in plain language. We all like to say that we're using plain language, and it's not often the case. What is very, very important to the trauma-informed part of this work is that there is no more lifelong silencing of victim survivors. So that's certainly where the permitted disclosures comes in, but also there needs to be mechanisms in which a victim survivor can withdraw from a non-disclosure agreement in the future, and far bigger consideration of time limitations on NDAs so that they're not kind of lifelong silencing situations. And, as I said, provisions to access support. And then finally, of course, with any legislation, we want to see that it's actually regulated, there's reporting and accountability, and that there's clear processes for dealing with breaches, and that penalties apply for the misuse of non-disclosure agreements. So we're going to get now to the Victorian Act, and I'm just going to take you through some key parts of this Act. As I said before, the objects of the Act are actually really important. They set why this legislation, what the purpose of it is, and also we know that legislation is regularly reviewed, and the Victorian Act will be reviewed in 3 years' time to see if it's meeting these objects of the Act. This legislation is very pro-worker. It's very, we think it's a really excellent piece of legislation that, really does prioritise the rights and the trauma that is experienced by dealing with the trauma that's experienced by people who have experienced sexual harassment at work, and the power dynamics that are involved in signing non-disclosure agreements. So I'll just briefly summarise here. It's about securing health, safety and welfare, minimising psychological and social impact of workplace sexual harassment, recognising the vulnerability and the power dynamics that people who experience workplace sexual harassment are subjected to, protecting and empowering workers, addressing the power imbalances in negotiations, and reducing the incidence of non-disclosure agreements being used to conceal workplace sexual harassment. I'm just going to go through some more key aspects. We'll just get a little bit more detailed as I go through. So hopefully I'll be able to give you most of the information that then you'll be able to go and find more for yourself as well. So in the Victorian legislation, non-disclosure agreements are the exception rather than the rule, and they can only be initiated by the victim survivor themselves. This Act, obviously, as you can see there, is a standalone Act with those comprehensive objects that I just spoke about just now. NDAs are only valid, so once someone signs a non-disclosure agreement, it can only be valid if these ethical preconditions have been met and signed off by all parties, and I'll go through what those preconditions are in this presentation soon. The Act applies to all types of workers, which is really excellent. So it applies obviously to standard employees, but it also applies to contractors such as sole traders, the public sector, and also volunteers in workplaces as well. It applies to all the different types of NDAs we might think about: confidentiality and non-disparagement agreements, settlements and deeds of release, of course, but also employment contracts. And in fact, the definitions we provided at the top of the presentation are taken directly from the Act. Anyone who's considering signing an NDA receives a plain language information statement, which is provided through by the Government of Victoria. It includes rights to seek support from health professionals, loved ones, and other designated agencies when an NDA is signed. And this is called permitted disclosures, and I'll go through them in a moment. It allows, this is a really key one, it allows victim survivors to waive their confidentiality and withdraw from an NDA after its first anniversary with no changes to the rest of the agreement, including compensation. And it includes a simple process for dealing with breaches, and the process onus is back on the employer or respondent. If they don't say, well, I don't believe that it's been breached, then it is null and void of the NDA. So this website here is the website for this Act, and it has a whole lot of forms and notices, as you can see there, that acknowledgement that NDA preconditions have been met. It's a form to sign when signing an NDA, notice of termination, and these information statements, of course, as well. I'll just go through some of those points that I made around the legislation in a little bit more detail. So these are the ethical preconditions required before including an NDA. And I will just say that some of the things I'm about to go through, while they're now legislated in Victoria in this Act, they are actually things that some lawyers have already been doing, some legal centres have already been doing. There are things that we can be done without, through changing practices in law firms. And it's not, we do believe legislation is required, but these are things that we can all consider in the way that we deal with these matters. So the request for an NDA is initiated by the complainant. It is their express wish and preference. They've received legal or industrial advice before they enter into the non-disclosure agreement, and they've had time to review the agreement. There's been no undue pressure from the complainant's employer, the respondent, or anyone acting on their behalf, and the agreement is in plain language. So these are all things that need to be signed off on when signing a non-disclosure agreement. Permitted disclosures. So these are, if someone has, gone through this process, they have decided as a victim survivor complainant, but they do want a non-disclosure agreement. They've signed off that the ethical preconditions have been met. When they sign a non-disclosure agreement, all non-disclosure agreements will have these permitted disclosures in them. Family or friends, for the purposes of personal support, who must keep the information confidential. Lawyers, unions, and also prospective employers for the purposes of the person obtaining future employment. Registered medical professionals, ministers of religion, of course, police and victims of crime organisations. And I guess just to kind of point out that in the NDAs that, we see at the moment, these kind of lifelong non-disclosure agreements that are being signed in these matters, there are NDAs where all of these things are banned from being opportunities for a victim survivor to speak to. Now, whether that is something that could actually be, enacted if someone wanted to, check whether you've been talking to your doctor or not is a whole other thing. But many victim survivors believe they can't even speak to their doctor about their experience of sexual harassment if they've signed a non-disclosure agreement. This is also really important. There's a range of public interest bodies that are included in the permitted disclosures. So parliamentary committees, this Australian Human Rights Commission, Equal Opportunity Commission, and so on, anti-corruption bodies, etc. And financial disclosures can be made to Centrelink, to financial advisors, and to the ATO. Time limitations. So just to talk that through a little bit further, in Victoria, as I said, a person can terminate their non-disclosure agreement on or after the first anniversary of the agreement with 7 days' notice. I'm just going to go through this a little bit quickly because I've just clocked for time. So time limitations are really, really part of the trauma that people who have signed non-disclosure agreements have said is really, really important to, removing some of the trauma that goes along with signing an NDA. This kind of they're there forever is one of the largest impacts on victim survivors. We know that victim survivors want some options and some control in dealing with their experience over time. We know that victim survivors can have feelings of regret about signing a non-disclosure agreement when they've had a chance to kind of process their experience. So say 6 months later, feelings of regret. People don't generally want to broadcast their sexual harassment to the world, and there's plenty of disincentives for people to do that in the first place. 12 months also affords an employer time to, deal with their issues and potentially tell a good news story. Essentially, this is the victim survivor themselves waiving their own confidentiality. So, the case for law reform. So, of course, we support law reform to restrict and regulate non-disclosure agreements in workplace sexual harassment and discrimination matters. As Maddie said at the beginning, workplace sexual harassment is preventable. Non-disclosure agreements undermine public transparency and make it impossible for governments and the community to know how often they're being used and what behaviours they're hiding. And when they hide these problems, organisations cannot address systemic cultural issues, manage their risk or meet their positive duty. And so if we ensure victim survivors have the choice to be able to tell their story, we can create greater accountability and positive workplace changes. And we can also prevent, side by side with that, the harm that NDAs inflict on individual victim survivors. I just want to briefly talk about federal law reform. As part of Working Women's Centre South Australia, we're part of the Working Women's Centre Australia National Network, who are also campaigning for federal law reform around non-disclosure agreements, and we support this campaign as well. It's a fantastic resource, this website as well, and I'd encourage everyone to go and have a look at the website, and things like that video that we watched today have been created from our network of activists, lived experience activists who are speaking around the country and to the Commonwealth around these issues. I do want to note, though, that only a few weeks ago, Workplace Relations Minister Amanda Rishworth issued a revision of regulations which enable state and territory laws to deal with NDA and non-disclosure agreements to operate alongside the Fair Work Act. It supports this concurrent operation alongside the National Workplace Relations System. Of course, this ensures that the Fair Work Act doesn't exclude these laws dealing with non-disclosure agreements. This really does greenlight state and territory legislation processes around non-disclosure agreements in workplace sexual harassment matters. So we think it's very, very positive. And it enables the federal government to consider the Speaking from Experience report from last year from the Human Rights Commission that I mentioned earlier, and also they're very shortly to do a legislative review of the Respect at Work Act in 2022, including the positive duty laws. So what do we want to see in South Australia? We want to see legislation that covers sexual harassment and discrimination, which are often really highly connected, as we've spoken about. We want to stop the lifelong silencing of people who have previously signed a non-disclosure agreement by making the permitted disclosure part of an NDA, something that is universal. And this has occurred already. There's a precedence for this in Canada, in the Prince Edward Island legislation that was passed in 2022. We would like to see 60 days to gain independent advice before signing a non-disclosure agreement in a workplace sexual harassment matter. In Victoria, it's 21 days. We think 8 weeks rather than 3 weeks would be better. Give people more time to seek that advice, obtain it from somewhere that they would like to obtain it from, and then make their decision. We, of course, want to see strong penalties for the use of misuse of non-disclosure agreements and a reporting process which keeps employers accountable. This can also involve working with the federal government on what the regulation framework might be. And we, of course, would like to see the funding of a strategy to inform and educate people, workplaces, workers, employers, and the legal sector on these new laws. So that we make, we're making sure that people know their rights and are enacting their rights. To summarise, doing this law reform in South Australia will build on providing stronger protections and support for victim survivors and stronger consistency with existing laws and principles. It assists workplaces to change culture, and it assists the community and society to advance the public interest in ending sexual harassment with transparency and accountability. There's more to do. We're very, very happy that the South Australian Government have committed to this law reform process, and we, need to do work in our communities, our workplaces, and our Parliament to see strong regulation enacted here in South Australia. We suggest that people can think about communicating about this issue with members of Parliament, raising this issue within your own union or law practice and with your communities. Keep on listening to the voices of victim survivors. It's so important. If you represent workers in these types of matters, thinking about updating your practices now, thinking about what that there is change and we can be the change as well. We have a whole stack of merchandise and campaign material at the Working Women's Centre Australia, including fantastic posters, similar, the same as this banner. So you're welcome to drop in and collect that for your workplace. And we believe that there will be a government discussion paper that will come out later this year, second half of this year, and that will be the first part of a consultation process towards what legislation in South Australia could look like, and we will be encouraging everyone and holding more information sessions about how people are able to make a submission and provide their own experiences, maybe as victim survivors or as professionals or as people who are very committed to changing the causes of workplace sexual harassment in South Australian workplaces. Stay alert. Unfortunately, we've gone a little bit over time. We would love you to complete our survey so that you can give us some feedback about the presentation. We are very available for emails for questions, and then we can come back to you about anything that's come up for you through this presentation or any further information that you would like. I see if Maddie would like to add some more to that.
Yeah, I'll just say that everyone should have received the link today from my email, so feel free to email me if you've got questions or would like to chat with us more about this. This is a huge advocacy priority for us at the moment because of the opportunity we have here with the government committing to law reform. So we're really keen to chat more about it, and also just want to say thank you all for your interest and for attending today's webinar. We really appreciate it. Anything from you?
Thanks, everyone. Stay tuned. Hope it's been helpful. And we hope to see you all submitting to the submission process later this year.
Stay connected.
Thank you.
Thanks.